Greetings. Today we're going to talk about federal estate tax. Now, we don't like talking about death or disability, and that's why you're probably on autopilot. Meaning, if you got a will or if you've got a trust, it's old and cold. Old meaning it's probably 10 years old. And cold meaning you haven't looked at it, you haven't changed it, some people may have passed away, some people aren't in your plan any longer. And so it's old, meaning it was done years ago, probably great design. And cold meaning it hasn't been updated. So it's old and cold, which means to me you're on autopilot. Well, we got to get you in the cockpit to unswitch the autopilot switch and put you in charge. We got 3 things you got to do because the federal estate tax is an entirely voluntary tax. You decide what they, meaning normally the kids, pay, when they pay it, and how much they pay. Totally voluntary. Under our taxing code today, there's no tax until the second death, assuming that a spouse survives the deceased spouse. And so there's no tax until the second death. But they give you a certain amount that's never going to be taxed. It started at $300,000 decades ago. So you can see that the federal estate tax is never designed for you. It was designed for working individuals whose net worth didn't exceed $300,000 and they lived on Social Security, if that. They might own their house. And so it was never designed for people who make a lot of money. Never. Well, that being the case, they give you a certain amount that's never taxed, and that's called the federal exemption. And today it's $12,400,000 per person, but on December 31st of 2025, it's going to sunset to $6 million per person. Half of it's going to go away. And there's a good possibility that the Biden tax proposal is going to further reduce it to $3.5 million per taxpayer. That means you go from 12.4 to 3.5 million, and that could take place on January 1st. Imagine that this is a train coming right at us. We see the light in the train tunnel. It's coming right at us. We know that one train is going to arrive December 31st of 2025, so we've got time to deal with that one. But the one that might surprise us is that there may be another train, same deal, that comes effective January 1 of 2023, and that's the one we got to worry about because it cuts the federal exemption to 3.5 million from 12.4, a 75% reduction. And that is directly going to impact them, whoever they are. So here's 4 things you got to do. We got to do 4 things before December 31st. Number 1, we need to compress the estate. We need to find out what's left of your 12.4 million, which we can do with you. And we need to preserve it by giving it away now. Whatever you don't use, we give away. It doesn't have to be cash. It doesn't have to be brokerage accounts. It can be investments and stuff, but we got to give it away. And we got to file a gift tax return in January for 2022. And we got to get an appraisal. So number 1, you got to compress the value of the estate by figuring out what's left of your exemption equivalents, and we got to give them away. Second, we can get them back. So you give them away, but I can get them back. Because if you make a gift in trust for the kids, we have what are called valuation discounts. You can Google those, valuation discounts. And we can get them back. So it's a wash to you, but it's a wonderful gift to them. So compress the estate. Second, look at what's left. And now is not the time to look at what's left. We take what your net worth is. Remember, net worth is assets minus liabilities is net worth. We got to take life insurance out of that equation. If you can change the beneficiary, it's in your estate, the death benefit. Got to go. Got to move it. And we can do that. And it can be instantaneous. We can have it out of the estate instantly. The next thing is that we got to look at, do we still have, between those two things, do we still have a residual estate tax? And there are 7 different techniques that we can use to eliminate it. And the third thing is you got to remember, or the fourth thing rather, is you got to remember, you got to file the 706 at the first death within 9 months. Or whatever we've moved, preserved, will move to the surviving spouse. You do those 4 things, you might preserve what is going to be paid by the next generation enormously. But it goes away if you don't have proactive. You probably do anything for your kids. This is proactive planning for them. The last thing is, get them involved. Most kids are clueless about the legacy. They're clueless about the possibility of a divorce if they live in a community property state or some other type of property state. Get them involved. And that's our message to you today. I hope to hear from you. If not, call your advisor. Follow these 4 steps, and you will save your children millions of dollars. Thank you very much.